day video news. We are at the Judiciary Committee. The meeting is from 3 to 5. Looks like all the committee members are here.
Yeah.
We did that, and then like 2 years later we left it, so I don't know.
How old are the kids?
I have 2 of them are 26, and one of them is going to be 24.
How are you?
Yeah, well, the 2 of them are graduates from graduate school next month.
Good.
Yeah, how about yours?
30, 29, and 20. Same
Wow.
wife. Same wife.
30, 20, 20.
Yeah, it's funny. People say, oh, 10 years. But actually, the first 2.
I know, well, we actually, our middle one, so I have 2 that are 27. One turned 20. I was so jealous. So everyone always thinks I have twins, and he always tells me.
They're all kids. My son went to college in New York. I came back. Plays in Miami. Just got married. They were baby, 5 months old. Great. And I met Megan in school in Miami. She works at the Cancer Research Plus. Great company. And my youngest is in college.
Where are you going to college?
My son went to Ford in New York. Five months ago, she understood my research. She was a communication partner at Marist. She wanted to switch up on the train office.
That's great.
Did your kids go away?
Yeah, they did the 2 oldest.
Yeah.
They went to Creem, and then the youngest went to yeah, UNH. Yeah, she loved the. So it's just really fun and here. My son was with his friends and now I'm moving to New York, and they got lost when it's like a customer car accident call and they just went for a bathroom. Still one my daughter is our community and she's not sure so I think if you would have yes. But they have a lot of
So I'm going to convene a hearing of the Joint Committee on Judiciary. I'm Brownsberger, State Senator. I'm the Senate co-chair, and I'm here with my House co-chair, Fernandes, Representative Fernandes. To my immediate right is my Senate counsels, and then let Chairman Fernandes introduce the rest of the We have Representative Vilas, Representative Roy, Representative Cronin, Vice Chair of the Committee, Representative Day, Representative Harrington, Representative Tucker, and Representative Bowden. Very good. So I'm just going to take people on the order that they have signed up, and I've got Vincent Dixon regarding 754, which is a proposal for a legislative amendment to the Constitution for term renewal process. So feel free to take the seat.
Thank you.
We're try to do these hearings in 3 minutes per person, but we'll get a little meeting today, given that it's not a big crowd.
Thank you. Thank you, chairs of the committee, and my own representative, Michael Daisy. My name is Vincent Lawrence Dixon, 60 Lake Street, Indiana, Winchester, Mass. 01890. Additional contact information is available upon request. I appear before you to strongly support a significant proposal of mine to contribute to important reform of our legal system, including our judiciary. Also accompanying my testimony, I brought a petition with 9 signatures of individuals who support this idea. I would expect that other signatures will be collected over time and submitted in support of this provision on which I am testifying. This is the term renewal constitutional amendment provision proposed in that which is known as number S54 S54, which introduces the concept of terms and review of performance to the position of judge, members of the Industrial Accident Board, and selected other officials. All such officials would have to be reappointed by the governor and reconfirmed by the governor's council every 10 years. No such official could serve more than 6 months beyond their term unless reappointed and reconfirmed. There are several aspects of common sense to this proposal. Most people in most jobs have at least an annual review. Many individuals holding substantial management and/or professional positions can be readily fired on an instant notice. Presently, judges and similar officials covered by this proposal are appointed and serve until retirement. Sometimes they are even recalled to service. Many anecdotal reports and many more serious reports point to judges falling asleep, not knowing the law, or wandering off base from the case in front of them and other problems. In our complex postmodern world, it is vital that our judges and key officials be current on relevant knowledge and held accountable to high standards. Being a judge is an honorable calling and a privilege, not a right. The directions of individual lives and society as a whole are influenced, guided, and often specifically directed by judges. The important legislative initiatives are secured in their effect, oftentimes by thoughtful and knowledgeable judges. Even important executive actions are importantly screened and/or sharpened by thoughtful and currently knowledgeable judges and other officials. As our society has come under numerous pressures, oftentimes it is courtrooms and judges that have provided needed individual solutions and general improvement. In recent decades, Massachusetts has improved our legal system and its options by developing victim advocates, victim impact statements, jury reforms, and end to trial de novo and other issues as well. There are clear and simple purposes for this proposal: to provide a required review for judges and other selected officials every 10 years. A clear distinction here: reappointment is permitted, no election process is introduced, the governor's council remains the body of ongoing monitoring. Respect the concerns of many that such officials should have a regular review of their capabilities and performance, as well as the extent of their continued current knowledge. Federal positions frequently have a 10-year limit. This does not have that arbitrary limit. Certainly, recommended guidelines could be created in carrying out this new standard. To permit the reappointment of those performing their responsibilities with quality and distinction. Given considerable concern about various officials and their current knowledge, those who remain current can and should be reappointed. Thus, the public would likely be strengthened in their respect for the knowledge and competence of judges and similar officials. To ensure that such appointed judges and officials do not serve on an open-ended basis, regardless of deteriorating performance and identifiable failures. In some way, this is providing a streamlined review process that permits officials to step aside in a graceful way or to be non-confirmed if there are significant problems. This is less severe than what is effectively an action for cause, which a petition of address mainly deals with. There are certainly many other aspects of the legal system to be reviewed, including the grand jury system. Meanwhile, we must have judges who are current, reasonable opportunity for monitoring and assessment of judges, and a lot more. I once thought of going to law school and took legal courses in philosophy to prepare. Along the way, I realized that I loved the great reform thinkers and was bothered by the all too much run-of-the-mill legal system. As Horace Mann helped to transform education, and many minds have helped to improve our legal system, it is time to take additional steps to improve the quality of the judicial system and related positions. This certainly does not preclude looking at the entire system and many individual reforms. In filing this measure, I sought to reflect and address important concerns about reasonable review of judges and those in similar positions. I welcome discussion and interaction with yourselves, your staff, and other relevant individuals in seeking to achieve passage of this measure. Certainly, I'd be pleased to know of others that may be interested. As some of you may know, I visited about 15 legislative offices yesterday, had some interesting conversations, and look forward to being in further touch. And thank you.
Thank you very much for your testimony. Are there questions from members of the panel? Yes,
Mr. Chair, one question. I'm just curious. We know federal judges serve during times of good behavior, state judges up to age 70. What's the significance of the 10-year mark?
In many federal appointments, in fact, boards and commissions, it's 10 years, period. We have some substantial evidence that boards and commissions in the Commonwealth have had other issues as well, and there certainly have been issues about this. Judges and technology and the socio-demographics of society have changed tremendously, and there's a sense by some people that some judges have absolutely kept up with that, and others have not. And I think it provides an opportunity to review that and allow reappointment. Reappointment is, I think, far more kind than saying it's 10 years period. It doesn't introduce the chaos and circus that some places have with elections of judges. There are other kinds of aspects, but I think 10 years is a reasonable point of time, and it also allows people to say, I've had a good service, I think I'll step aside, as opposed to having to ask somebody who's been there for 20 years, who's clearly deteriorating in terms of their performance or their attitude. And more important, the stress, I think, that I've seen talked about in terms of lawyers and judges, especially in the urban settings, is a real factor. And a lot of judges will plow through it because they're there, but if you gave them the opportunity to step aside, I mean, we have some great law schools and some great graduates, I don't think we would lack for the appointment possibilities.
Thank you.
Other questions from members of the panel?
I've got one, Mr. Chair, and welcome, Mr. Dixon.
Thank you.
I've got to know Mr. Dixon as an active and engaged citizen, so welcome. What is your response to the criticism that this would introduce a chilling effect on the judiciary, that this would introduce a political equation into the judiciary, in that a governor who may want to leave his or her stamp on the judiciary will then lean on members of the council to essentially not renew a judge up for renewal under your proposal?
In thinking about these issues, I'm very sensitive to that fact. Hence, I've long opposed the election of judges, which some people would like to have, which is clearly political. I think that there have been discussions by a variety of people that there ought to be a better level of training for judges. Some people have thought perhaps there ought to be a separate track where people are trained to be judges. Coming out of law school, I understand in England that is used to some extent. Would be an interesting exploration. I think there's some issues. We know there's issues with grand juries. The fact is that the governor, most of the time, serves 2 terms perhaps. So the amount of influence they're going to have is perhaps important, but not necessarily determinative in terms of things. And stare decisis, which requires judges to follow past precedent to a reasonable extent, certainly diminishes that, as long as you don't have a process that's a actual election process. I think to some extent, in fact, there has been in this system, oddly enough, on issues of capital punishment and abortion and other issues, a very lively and sometimes excessive political set of arguments. So not having an election system hasn't prevented that. We, I think, want to have a review process that's very clear and is a review process, not an election process. And I think that's, you know, there's a balance representative that I'm well aware of. And I would like to see further exploration. I do have another proposal that may come here in terms of looking at the grand jury system. I think long-term better training for judges or training in law schools for the role of judges is an important one, because we know arbitration and mediation are becoming much more important as an alternative way of resolving disputes. I think one of the things Massachusetts really hasn't had in some years is look at the entire law enforcement system. We have had a series of individual gestures like victim advocacy and impact statements, which are good, but perhaps it's time to look at the entire system. This is just one thing that I think would be helpful in that broader picture.
Thank you. In some respects, I think you're dead on. However, I do have some of the same concerns about the politicizing of it. But what I don't know if maybe might be a better avenue for people to look into is sort of the access to the Judicial Conduct Commission. It's really only employed in very, you know, pretty serious situations, not when you have someone who's become maybe infirmed by some dementia or something else, and that they're still sitting up there. So I feel like more than, because then we have some other judges that have sat there well after 10 years. There may be some lawyers that don't agree with them because of the way that they view things from the bench, but they haven't really done anything wrong. So I'd hate to see it become sort of a witch hunt for those people that are not popular, but are not really doing something wrong. And it seems to me that maybe the standard has to be changed more on the Judicial Conduct Commission, so that people falling asleep all the time or something like that can be brought to their attention without making it like a bad behavior type of issue. I'd sort of rather see that to protect them a little bit, but not take down the good ones because they've done something unpopular or somebody who has some force and power.
I appreciate the comment. I have certainly thought about aspects of that, but it's interesting that we have these bodies that could be used and in fact aren't. And the fact is, I think that history has shown that when you have a constitutional standard requiring end or a adjustment in some way, that it's more likely to be done than what are laudable bodies that maybe should do something, but in fact often haven't. Hence all the boards and commissions, of which there are hundreds, some of whom have not been renewed. I think one or two of whom turned out to be living out of state or have been deceased. You know, that's another whole set of things. This is, I think, much more important because we're dealing with the future of individual lives and circumstances. Those boards and commissions are another example of what some would call sunset. I don't call it so much sunset as the need to review, because I don't think somebody should just be ended in their service, but they should be given the opportunity to go through a process. And by pointing in there the public policy considerations, I think it well permits the possibility of having some standards developed to respond to this in a very specific way. It would give the Governor's Council more responsibility, and maybe they could actually rise to the occasion, but since they usually have a little extra time on their hands. And there have been some issues that have come up in those areas over the years, but an elected body of people should have some say in this, and I think that this would tend to encourage some greater public debate. The fact that 50 years ago victims didn't have advocates or the ability to even talk about impact in courtrooms, and now do, came about partly because of political process, and it has been largely an informative and useful process for individuals and families who otherwise didn't have a role in court. And it shows the capacity for good reform in what is a Commonwealth, some very good history. Our Constitution being the first. I'm a tour guide in Boston and Cambridge, and I never tire of reminding people John Adams wrote the best Constitution in the world, which we still have.
Right.
Thank you.
Thank you.
Any further questions? Thank you, sir, very much for your testimony.
Thank you very much.
While we're on this bill, let me just ask, are there any people, other folks here to testify on Senate 54 regarding terms?
And this, by the way, was the petition with support for it.
Thank you very much. Seeing none, we'll move on to testimony of Ann Lambert regarding Senate 57.
You know, actually, Senator, my witness sheet said written testimony only. I'm happy to talk.
Well, that's prolonging. Have you submitted written testimony already?
Yes.
Has that been distributed to the members? Okay, well, does anybody wish to raise any? Why don't you take some additional moments, see if anybody has any questions for you while you're here. I thank you for attending. Does anybody have any questions? Why don't you give people a moment to glance at the end of your what you submitted in writing, which is we do appreciate, and then we'll just see if anybody has any questions while you're here.
My goodness, you treat it like an assignment. I didn't mean it to be that way.
No, we take your testimony seriously. You're speaking on an important issue. I take it that currently Article 48, which governs initiative petitions, does exclude a number of measures, for example, religion, religious practices, and so forth. So this is not adding a new clause, but just adding some items into the existing clause that seem to be missing from that clause.
Yes, exactly.
And those items would be?
Quality rights.
Freedom of equality, of right of individual, and enjoyment of life, liberty, and property, according to state laws. With that background, does anybody have any questions at this time?
I actually have a fairly simple question, and I might be really naive about this, but Governor's Council, I understand, you know, what they do. What does the Executive Council normally do?
The Executive Council is the Governor's Council.
Okay, that's just another word for the governor.
I think so, yes.
Okay, all right. So if they are in fact the same entity, aren't a lot of the this looks like it's, you know, sort of to make their discussions much more open and such.
Hold on a second, you're
She represents.
Maybe I'm reading this incorrectly.
Go ahead.
I think that this proposal for amending the state constitution
I think you may be looking at the
doesn't go to, yes.
I'm like,
We're referring to 757. You're looking at 56.
sorry, I was looking at the wrong bill.
Yeah, that happens. So this is just on the initiative petition issue.
Can you suggest a situation you've seen where this has caused you concern?
This particular proposal has been filed several sessions, going back to a time when it was a very live issue here. This comes in the wake of the marriage equality debate, when indeed there was a signature drive to amend the Constitution in Massachusetts to take away equality rights. We've come a long distance since then, and this is still with us, though, as a proposal to amend the state constitution. It's a good idea. We should follow through on it, even though it's not the subject of a royal controversy right now.
Well, and to that point, the marriage equality debate initiated because of an SJC decision, correct?
Correct.
If that was not affirmatively embedded in the Constitution by express words, would you then suggest that if the SJC decides a constitutional right, that it would be beyond, therefore, the right of initiative petition as a result of this to take exception to that?
What this is designed to do is to prohibit a popular, signature-driven initiative to change the Constitution. It's always open to the legislature itself to change the Constitution. That could be done in response to, well, I suppose court decisions for that matter, although the saying that excluded matters are something that should be very much in the legislature's consciousness. What this proposal would do is add to the excluded matters equality rights as expressed by the SJC, correct, and as expressed otherwise.
Okay, so if the SJC rules, then initiative petition would be out of question.
On equality rights grounds, right.
Okay, thank you very much for coming up, and we appreciate it.
Thank you, Senator.
That is the list of everybody who has signed up to testify. Has anybody else here to testify? Seeing none, entertain a motion. Second that motion. Thank you, committee.